I got a lot of questions and comments involving my video as to whether or not Joe Biden as president can declare a state of emergency or a state of war and ask or demand Americans to turn over their guns and ammunition to the government for the good of the country, if you will. And one of the things that got flagged is what happened after Hurricane Katrina. And I want to talk a little bit about that because that was a big deal in 2005 when we had the debacle in New Orleans and Louisiana dealing with Hurricane Katrina. The good news is there was a lot of favorable laws that came out of that. And I want to make sure that all of you are familiar with your state's laws because you need to know this because a lot of times the police may not remember these laws. So let's talk about it when we get back. Hey folks, I'm Mark Smith, host of the 4-Box Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of Disarmed, What the Ukraine War Teaches Americans About the Right to Keep and Bear Arms, lessons that the Israelis should have learned, and maybe they will now, but we'll talk about that later. All right, folks, so I did a video as to whether or not President Joe Biden has the legal authority under federal statutes or otherwise to basically take away our guns in the name of a national emergency or a wartime effort. Generally speaking, the answer is no for a whole host of reasons, not least of which is the Second Amendment itself. Nevertheless, a lot of you asked me questions about natural disasters and hurricanes and whatnot, and some of you specifically asked about Hurricane Katrina, which occurred in 2005 during the administration of George W. Bush. So I thought I would just talk a little bit about that, bring you up on some of the history that touched fingers with that, also some of the laws that got enacted at the time, and then I would encourage you to take a look to see whether or not your state's laws have similar provisions that protect people in the same way that, let's say, Louisiana now has, because they, of course, dealt with the Katrina and the fact that, frankly, there was government officials and police officers that confiscated over 1,000, that's right, over 1,000 firearms were confiscated, many of which were never returned, as I understand it, to the people from whom they were taken. So let's start from the beginning. In 2005, there was a hurricane called Katrina. We're not going to get into the details of this, but one of the problems it had is the levees in New Orleans broke. A lot of debate as to why that occurred, whether they were properly maintained by the city or not. Again, we don't need to get into those details. The bottom line is you had Hurricane Katrina, and the aftermath of Hurricane Katrina gave rise to flooding of New Orleans for a whole host of reasons, and it was a total mess. A lot of people died down there. As to whether or not the government response was adequate, you can have that debate, both at the federal level, the state level, and the city level. But we don't need to do any of that. What we do need to know or talk about is what happened down there. Is one thing that is undisputed is that at the time, the government down there, and there were different government agencies there, state and local, city, that actually went through the process of taking away firearms in the name of public safety, believe it or not. Specifically, and I'm going to read to you from a law review article by a friend of the channel here, Stephen Halbrook. Many of you are familiar with his work. You probably have read his book. He wrote a law review article because he was one of the lawyers that represented the National Rifle Association down in New Orleans that sued on behalf of the gun owners and tried to enjoin and stop the government from confiscating these firearms and then ultimately to give the guns back to the people from whom they were taken. So this is what he wrote about the situation. Quote, "When Hurricane Katrina hit New Orleans in 2005, the police declared that only law enforcement would be allowed to have guns and that lawfully possessed firearms would be confiscated from civilians. Police proceeded to seize firearms at gunpoint from persons in their motor vehicles, boats, houses, and business premises. Citizens were left without protection in a city besieged by looters and criminals." So that was what was going on according to Stephen Halbrook and according to lawsuits that were brought by the National Rifle Association and by the Second Amendment Foundation. And it turns out that indeed the National Rifle Association at the time filed a lawsuit in federal court against New Orleans Mayor Ray Nagin and obtained a preliminary injunction against any further confiscations and an order that firearms be returned to their rightful owners. Now, what's interesting is this all occurred in the year of our Lord 2005. And to you who watch the 4-Boxes Diner channel and thus are the smartest people in the room, you know why that's significant, because the first Supreme Court decision that speaks to the Second Amendment in the modern era is, of course, the Heller versus D.C. decision, which was decided in 2008. So here you have in 2005, which is before the decision by the Supreme Court in Heller, saying that indeed there was a right to keep arms, and these police officers were not allowed to do what they do by taking these firearms, which is what happened. Now, ultimately, I'll give you the good news as in terms of litigation. The final decision was there was a consent order entered in October of 2008 a consent order granting permanent injunction and dismissal of remaining claims against defendants Ray Nagin and Warren Riley. It goes on to say that this consent order said, and this was by the court, it was a case called National Rifle Association of America and Second Amendment Foundation versus Ray Nagin. It specifically said that the defendants and all their agents are hereby enjoined in order to cease and desist confiscating lawfully possessed firearms from all citizens, including but not limited to members of the Plaintiffs' National Rifle Association of America and the Second Amendment Foundation, Inc. It is further ordered, adjudged, and decreed, this is the court order again, that Ray Nagin, in his capacity as mayor, and Warren Riley, in his capacity as the superintendent of police of New Orleans, shall attempt to return any and all firearms which may have been confiscated during the period of August 29, 2005, to December 31st, 2005, in that multi-month period, by the defendants, their officers, deputies, agents, servants, and employees of all such persons from members of the Plaintiff NRA or Plaintiff Second Amendment Foundation who lawfully possess firearms and all other persons who lawfully possess them utilizing the following procedures. And then it goes on to discuss how this should go down. So the good news is that there was a decision that said that the defendants had to turn back all these guns that they illegally had confiscated. Now, what happened, I think, was there were some issues in terms of how you could prove that a gun was yours. Because keep in mind that a lot of people who lost their guns or whose guns were confiscated, they lost a lot of things in their homes. They lost a lot of paperwork that was destroyed in the flooding of New Orleans during Katrina. So as I understand the story, is a lot of people, practically speaking, would go to the police department and say, I'm here to pick up my shotgun. I'm here to pick up my gun. And the police would say, that's great. Give us proof that this is your gun. Give us some paperwork that you bought the gun. Show us the original paperwork. And of course, the dilemma was that these individuals had lost their paperwork, they had lost their receipts, they had lost the information that showed they acquired these firearms in the first place because they were the victims of flooding and a lot of the paperwork was destroyed. So you can see the catch-22 that a lot of these individuals were put in by the fact that the government confiscated the guns in the first place. So in response to this, and I'm going to give you now the good news, it's an old speaking technique as a side note that I used to learn when people, as I would give public speeches and do debates or whatever, that, you would give people the headache and then you would give them the aspirin. So here I gave you the headache as to what happened in Katrina, but now I'm going to give the aspirin, the good news, which is that both the federal government and the Louisiana state government took steps to make sure this never occurred again. Louisiana specifically enacted, and this is under their state statutes, 14:329.6, they did something involving a proclamation of a state of emergency in firearms. Specifically, they wrote, quote, the right of each citizen to keep and bear arms is fundamental and shall not be infringed. Nothing in the section shall authorize the seizure or confiscation of any firearm or ammunition from any individual who is lawfully carrying or possessing the firearm or ammunition except as provided in the subsection below. And the subsection below basically says the only time the gun can be taken away from you is A, if the police officer believes that you've committed a crime, meaning you've been arrested, then of course if you're being arrested they can take away your gun, or if they need the gun for some sort of evidence associated with a crime for however that might arise. But those are the exceptions. And then the Louisiana statute that again was enacted in 2006, June of 2006, and I think it was subsequently amended and broadened. But the bottom line is it goes on to say that firearms and ammunition manufacturers, distributors, wholesalers, suppliers, and retailers and shooting ranges are essential businesses, and operations for purposes of carrying or possessing the firearm or ammunition are, of course, protected. So the bottom line is that all of these things are protected even if there's an emergency, and it specifically says that you cannot take away these guns, nor can you shut down these businesses or restrict them from operating or conducting business even during a declared emergency or a disaster. So that's very good. That's the sort of thing that Louisiana did as a state matter after the debacle of 2005's Katrina. So in your state, you may want to take a look to see whether or not there's these provisions that says your state government, state police, local towns and whatnot, they're not allowed to take your guns in the event of a declared state of emergency or disaster relief or any of these things by your governor or mayor or whatnot. And if it's not there, you may want to contemplate talking to some of your elected officials to see whether or not a Louisiana-style law can be enacted. But it wasn't just Louisiana. The federal government stepped in and actually enacted something. That's Congress specifically. After Katrina, they enacted a federal statute that dealt with the prohibition on confiscating firearms. Specifically, this is 42 U.S.C. Section 5207. That's Title 42 of the United States Code. Section 5207 says that you cannot confiscate firearms in the event of emergency. Specifically, it says, quote, no officer or employee of the United States or person operating under the color of federal law may, goes again, I'm not going to give you all the specific words, just the essence, but basically no one working for the United States or acting pursuant to the United States may, quote, temporarily or permanently seize or authorize the seizure of any firearm, the possession of which is not prohibited under federal, state, or local law, other than forfeiture in compliance with federal law or as evidence in a criminal investigation. Again, if you're lawfully allowed to have the gun, they can't take the gun away from you. Now, if you're carrying an illegal gun or you're a prohibited person or the gun is needed for evidence in a crime, let's say, well, then they can take the gun away in the normal course of law enforcement processes. But the bottom line is they cannot confiscate the gun in the name of a national emergency, a wartime effort, or any of these things. It goes on to say that also they may not prohibit the carrying of firearms by any person otherwise authorized to carry firearms under federal, state, or local law solely because such person is operating under the direction, control, or supervision of a federal agency in support of relief from a major disaster or emergency. Now, it goes on to have some limitations dealing with being able to be transported out of an emergency area or major disaster area and whatnot. But it also goes on to have a private right of action. It says if, and this is very good news, if an individual such as yourself is aggrieved by violation of this law, they may seek relief in an action of law, suit, inequity, or other proper proceeding for redress against the person who did it. And you get your attorney's fees potentially. By the way, equity means you force someone to do something, so you have a claim for equity, which means, for example, I can make you give my gun back. That's a claim in equity, meaning you're forcing someone to do something they don't want to do. That's what a claim in equity means. Or it also says you have a claim in law. Claims in law includes the legal remedy of money damages. So, for example, if they've taken your $2,000 shotgun and lost it, you have a claim to give it back to you. And if they don't give it back to you, you have a claim for legal damages in the form of monetary relief. Equity means you force someone to do something they don't want to do. Legal means something about involving the payment of cash or money. And of course, here it says you both have claims in equity and in law, which means for money and you get your gun back effectively. And again, this is federal statute. So the good news is there was a lot of good steps taken after Katrina. So again, we sometimes talk about how bad news, bad events can give rise to good stuff, better things, improvements, which is kind of how the human condition work or should work when they're back again in Katrina. The police confiscated over 1,000 firearms, apparently unlawfully. That got fixed not just through the lawsuit brought by the NRA and Stephen Handbook and the Second Amendment Foundation. It also got fixed by Louisiana state law and the federal law as well. All right, so I just want to wrap up one additional thing. When you're dealing with confiscating the firearms, you're not just dealing with the right to keep firearms under the Second Amendment. You're also dealing with another constitutional amendment, at least one additional one, and that is the Fourth Amendment law that prohibits unreasonable searches and seizures or warrantless searches and seizures absent special exceptions. And do not ever forget that because, again, one of your best defenses to you perhaps protecting your gun rights is making sure the police aren't allowed into your house without a warrant, that you don't talk to the police, you don't give them any information, that you're not required to give them, if any. And again, that's why these other parts of the Bill of Rights are there, and you should make sure you exercise all of your rights, not just your Second Amendment rights, but they all work to protect you, including your right to keep and bear arms and your property rights and, of course, your freedom. I do want to mention one other additional point that Stephen Halbrecht made about exactly this in his article where he discusses his case involving Katrina and the NRA. He writes, quote, the mere presence of a firearm does not justify a search of or seizure from its apparent lawful possessor. He then quotes a famous case we talk about on this channel a lot. That's the Staples case. He goes on to say, quote, owning a gun is usually licit and blameless conduct. Roughly 50% of American homes contain at least one firearm of some sort. Common sense tells us that millions of Americans possess these firearms with perfect innocence. Police officers may stop and briefly detain an individual for investigative purposes if they have reasonable suspicion that criminal activity is afoot. However, apparent lawful possession of a firearm by itself does not give rise to reasonable suspicion. Hear what I just said? Apparent lawful possession of a firearm by itself does not give rise to reasonable suspicion. Stephen Halbrook in that article. I'll put a link to it down below. So, all right, folks, hope you learned a little bit something here today. Again, it's my job to not just tell you what I read on CNN this morning. I'm trying to give you information so you can plan your lives and think about things ahead of time, so you can think about this stuff and contemplate it. Because, again, it's far more important that you think about these issues and be ready for them and think down the chessboard, because that's what we all need to do here in the Second Amendment community. Because metaphorically, as Ben Franklin said to his other founding fathers upon the signing of the Declaration of Independence, we must hang together, or most assuredly we'll hang separately. And I think that metaphor goes for the Second Amendment community. We must hang together, or we will all lose our right to keep arms, and who knows what else in the process. All right, folks, hope you enjoyed today's discussion. If you haven't subscribed to the Four Boxes Diner, please do so. Make sure you like this video and circulate to your friends. And don't forget to follow me on X or Twitter at Four Boxes Diner. And we will see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.